afternoon. I'm going to start off with what might seem to be a completely irrelevant series of questions for you. The first of all is, I don't know how well publicised it is, but the plan is after this to take you all across the Schloss across the road. We've hired an area for some drinks. I appreciate this feels a little bit mean to those of you who are online, won't be able to join us, but that was your decision. We're going to crack on now with our final session of this afternoon, which is running travel cases collaboratively. The great they says practice makes perfect. So in order to try and get this right, in April, Claire and Craig and I convened to have our first run through this, and then ended up having quite a few beers afterwards, at which point I had to look at my notes and try and work out what we'd agreed to talk about. Our second run was on Tuesday, at which point about an hour, Craig reminded me that we'd be talking for an hour, and we're only supposed to be talking about 45 minutes. So we've got our extra 15 minutes now, Craig.
Exactly what I wanted.
Absolutely. So hopefully, as the great they also say, third time lucky, we'll see how this goes. So what we're looking at is how to best run a case for the interest of your respective clients, yet also trying to run the case collaboratively so it is less stress-free, or when you encounter difficulties, you may be able to look to your counterpart on the other side and deal with things without having to go through the contentious issues of always fighting everything through court. So what I'd like to look at to start off with in terms of a generic position is just some indications, Craig and Claire, who I haven't introduced, leading partners at Leigh and Clyde Co, experts in their fields, not going to say anything more on that in terms of timing, is the importance of relationships with your opponents and relationships with co-claimants or co-defendants who you're working with.
Well, for me, it's of paramount importance, really. And I think, well, we should have called this talk, why can't we all just get along? And it probably would have worked much better if there was a claimant lawyer and a defendant lawyer that really didn't get on at all at the start, and would have been more entertaining for you. Luckily, we do. But it really does make a difference. And particularly in the field of international and travel law, it's quite a small field. A lot of the practitioners are in the room today. We know each other from conferences. When the cases come up, 9 times out of 10, we know who the opponents are. So if we don't get along, we're going to see the same people over and over again. On the cases that we do run, it is really important. And I think collaboration can work on many levels. The cases we're going to get are either going to be large catastrophic cases, or they can be smaller fast track cases. Collaboration is possible on both. Again, it can be cases where liability is admitted or not admitted, or they can be pre-issue and post-issue. It's like a matrix. Collaboration is possible no matter what you get out of those, but it looks slightly different. Obviously, if you have a large CAT case, which is pre-issue and liability has been admitted, then you're almost negligent if you aren't working very, very closely with your opponent. If it's a smaller fast-track case where you've got a liability dispute, collaboration will look something different, such as working on the case quickly, proactively, and not taking the points which are going to build costs for your client. To do all these things, you need to have an excellent relationship with your opponent. I think what we always try to do at the start of every case, whether it's a smaller case or a larger case, it'll be in person if it's a larger case, is to have an initial meeting between the legal teams. If I've got an insurer client that's based over in this country, I'll take them with me to meet the claimant team, because it's like they're going to be working on a case for 18 months, 2 years, and so on. I would like to use that initial meeting really to case manage a case ourselves, scope out where we both think we're going to, look at issues such as jurisdiction, if there can be any agreement or an applicable law and so on, and try to get an agreement from the onset. And so to really do that, you need to have a relationship with your opponent. If it's a new opponent, you try and forge that relationship very quickly from the start.
Yep, I don't disagree. I think, as Craig said, everyone in this room probably knows each other quite well. There's some really familiar faces. And there are people who have worked on both sides of the travel law sides. They've been claimant lawyers and defendant lawyers. And there's a small amount of people who work within this really interesting and important area of law. So inevitably, our paths will cross at conferences and then cases. So it is an advantage to know your opponent and to try and make sure that that is put in the best interest of the client. That's ultimately what we're all here to do, whether or not your client's a lay client or an insurer client. And what you want to do, our job as lawyers is to work in the best interests of our clients. And if that means we have to collaborate with the defendant, then obviously we will. The object of the exercise, and I think that sometimes lawyers can forget this, the object of the exercise for us as claimant lawyers is to settle the case and to get the best outcome for our client. It's not to have our petty disputes and or any sort of any old cases historically coming into this case. It's about making sure that you're acting in the best interest of your client and upholding your duty to the court. So it's really good when you get connections with defendants, because you think, well, I think I can work with them. And on bigger cases, we'll go into it, but on bigger cases, that's absolutely key. Because when it comes to things like rehabilitation or case management or interim payments, then having that relationship with the defendants, who ultimately be the ones that we want them to pay for it, is going to be absolutely crucial. So it doesn't work all the time, but ultimately what I think, and I would hope that everyone is thinking, is how can it, they're not the enemy. Let's try and collaborate. Let's try and work for the best interests of the client. So yeah, I think it's good practice where possible.
Just picking up on that, I think you made a really good point there. It's the best interest of the client, which is the claimant works on, and also the defendants. And I think a popular misconception of how defendants work is we're trying to get rid of all the claims, defend them, and totally get rid of them. But an insurer looks at the clients, the only thing they want is to get the right results on each claim and the best result for themselves. And that actually has a big overlap with the claimants getting the best result for their clients. I mean, there's an interesting talk before from Jatinda where they say they vet a lot of claims and he gets rid of a lot of claims which he doesn't bring to be brought forward. If a claimant's list is doing the right job and not taking claims which are either fraudulent or there's no evidence to support them, then you can be working together. The claimant getting the best result for their client and the insurer getting the right result has a big overlap. There's obviously some scope in there between where you eventually settle on, but you are competing, but you're not polar opposite to the end. You can both land a case in the right spot to keep both of your clients very happy.
In terms of getting that proverbial ball rolling to get the accords, particularly in bigger cases where it justifies putting that bit more effort in early on, could you talk through initial engagements in terms of planning how the case is going to go forward, perhaps contemplating, is this a case where you might want to hold back on issuing, and what can be done to maybe hold back on issuing to get some of the issues dealt with, perhaps not without even needing to involve the courts?
Well, the first thing we would do is try and establish who the defendant is or who the defendant insurer is. So I'm thinking of a case I've had where you find out who the insurer is and you might have dealt with them, you know who the solicitors are, and you might have dealt with them in the past. So the case I'm talking about involved a need to repatriate the client pretty quickly from Europe back to the UK as soon as they were stable enough to do so. And once we found out who the insurer was and therefore who the solicitor was, we knew that we had worked with them before and we'd worked very well with them before. And we were pleased that they were, sorry to use this phrase, a sensible insurer. And therefore, I was able to drop an email to the person who I thought was going to be my opponent and was. And we were straight away dealing with case managers, rehabilitation, repatriation. Sorry, repatriation was the first step. And that was key to find out who that was. And it was a huge relief to find out it was this particular solicitor, because I knew that it would be from the beginning a collaborative process. And we ended up being able to repatriate the client, agree a case manager to help with that repatriation and get the claimant back to an English hospital. So it was absolutely invaluable from the beginning to have that. I mean, if it had been another insurer, then it might not have been quite so useful. But in that situation, it was key to have that past relationship and know that they were going to be right from the off. It helped that it was a passenger in a vehicle, to be honest. That also helps as well. But that was really key right from the beginning.
Yeah, I think that's something slightly different with international cases, is defendant lawyers can quite often get instructed much further down the line and much later than we want to be instructed, really. The earlier that we are instructed from this country, the more we can help on the case and the more we can liaise with the claimant side. I think it's very rarely on international cases that defendants will know about a case before the claimant. It does sometimes happen in EL cases, even in some RTAs. And actually, in those instances, we've actually had a case where we've liaised with the claimant directly and actually recommended people we know we can work with over here for the claimant to go with. We've got an obligation to litigants in person and recommend sensible lawyers. And so actually, if you do work collaboratively with us, then it's good BD for yourselves, because eventually one day we can send you some cases. So that should be incentive all you need. And so obviously, yeah, the sooner we get involved, the more we can help. And I think that is important.
There are occasions when you don't want to get involved with the insurers from the off. You want to keep your powder dry. I think Cheryl mentioned it before in relation to the negative declaration spoiler proceedings world that we inhabit. So there are occasions when you have to take a view and balance whether or not you want to engage early with the defendants or whether or not it's in your client's best interest to keep things back. And indeed, we all know that can happen in Belgium, where as soon as you send a letter of claim, then they will do a negative declaration in the courts there, which seizes the courts there. This is obviously what used to happen. So there are situations where I take a view and we decide not to do that, which is obviously not always what you want to be doing, and not engaging with the insurer from the beginning, but for the better interest and to keep the client's case within England, then we have to do that. So it's about, from the beginning, looking at the case, looking at where the potential jurisdiction could be, what your knowledge of those pitfalls, the bear traps that might be coming, and making a decision, again, going back to what's in the best interest for that client. And it might be to engage early with the insurers because you know you'll get the rehab, or it might be do nothing for the time being.
I suppose it's those situations, isn't it, where you're wanting to collaborate when you can, it's in the best interest of your client, but when you've got a Belgian insurer, or the risk of an Italian torpedo, or an experience I've had, overly aggressive Norwegian insurers, you need to keep quiet. I've never thought that these are quite aggressive. They really are. Never cross a Norwegian insurer. Never cross 3 of them. It's even more risky. But there's a pro quo where you realise there might be procedural consequences to that. There might be issues later on the line that you didn't tell us, you didn't engage. But you know that there's the risk of proceedings starting in Antwerp, which you really don't want, and that's 5 years of fact that you don't need. But
I guess on that point, though, it's know your opponents, isn't it, really? And
yes.
the claimants really keep a kind of a database, if they can, well, DPA provided, of who the insurers are in certain cases and how they tend to react. Because I can guarantee you most insurers, we won't know about the case because insurers don't send it to us until they find out proceedings are instigated over here. Most often they don't, but the insurers will know about the accident, and insured has an obligation to report an accident, otherwise it's not going to be covered. And so the insurer will know, and they'll start doing things behind the scenes. I've had cases before where we've picked up, I'm thinking for a very serious Spanish RTA now, way before we got involved. There was a brain injury case, an English claimant, very severely brain injured, and the Spanish insurer tried to bring claims for vehicle damage against the claimant. Obviously, we would advise against that if we were instructed beforehand. Once we got the case, from the very onset on that case, it completely soured the relationship with the claimant's team. And so we had a lot of work trying to get that case back on track.
And AXA are currently the well-known insurer who are doing this. And just for those who don't understand, what will happen very often is somebody will cross a road in Spain. They may end up with catastrophic injuries, and I've got a similar case at the moment. And the insurer of the vehicle which collided with the individual will bring a claim against that individual for the broken headlamp. They'll start those proceedings in Spain, and then there'll be an argument to say that the jurisdiction has been seized in Spain. And depending upon how quickly you can act to challenge that, you may well end up with a liability decision in Spain, which can be unfavourable depending upon what kind of expert evidence you can get. And then you've got the decision as to whether or not you want to run the quantum aspect of it back here. But that kind of action, which some might call petty, others might not characterise it in that way. Craig, if you're then dealing with the consequences of that afterwards, and there is a sour taste in the claims now, how do you then look to get things back on track?
You've got to start afresh and say there's a new legal team involved. Obviously, we weren't involved in that decision. That was taken by the overseas foreign insurers. If we were instructed at that stage, we may have advised differently depending on the case. And I think, again, it's very important to have that first roundtable meeting. You say, okay, look, this has happened, but this is where we are now. And if we can set something going forward, how we're going to work on the case. What I like to do on very big cases, going with the claimant solicitor, is see if we can get a memorandum of understanding where we completely roadmap the case. And we set out if there are going to be interim payments, when we can structure them, what experts we're going to be using, We've even had creative things in there, such as a time limit when we agreed not to make any Part 36 offers, which I think is much more relevant today following the recent decisions on Quox. And so you can be quite creative on these, and that shows that you are prepared to work with the claimants by giving these concessions.
And what are you looking to
Yeah,
get
what do you
from
want?
it? what are you after?
Even in a collaborative talk, the suspicion of the other side still. We need to move away from that.
We didn't
Definitely.
mention that though. What do you want from us? in
Yeah.
return?
So the benefits you really want, like I said, we're trying to get to the right results for both parties. So to do that as soon as possible, we want access to medical records and all case notes at the start of a case. We don't see much reason to withhold them or not to disclose them to defendants at the earliest possible opportunity. We want access to the claimant for medical appointments and to be no issues or barriers put in front of those. That's the bare minimum that we want.
And moving on to a specific example, rehab schemes and how that fits in with foreign insurers. There's not an obligation on foreign insurers to engage, but Craig, what do you say to them in terms of whether or not they should consider engaging or not? And Claire, what are you saying perhaps to more difficult defendants to encourage them to get involved in that?
Well, obviously, the serious injury guide and the rehab code, foreign insurers aren't signatories to that anyway. And so we have to really sell the benefits to them. I think it's going to be more difficult if there's some arguments of split liability. Obviously, if there's arguments of split liability, if the claimant goes ahead and instructs various rehab provisions anyway, there's going to be the deduction on that at the end of the case. If there's no split liability and we don't engage in the rehab, you're going to be paying 100% either way. But what we need to look at with the insurer is look at the possible benefits. And we've got many success stories of rehab having massive savings on the case by investing early at the onset of the case and saying, if we do this, we're likely to get these savings in the future. And again, it depends on what the applicable law is as well. So you need to look at that and what countries' insurers you're dealing with. But you do go through the insurer and say, listen, if we do get involved in this, let's get an INA. Let's see what is needed, when it's needed, how it's going to be provided, how much it's going to cost, and do we think it's going to make any savings in the long run? And if so, then we'll certainly recommend it to the insurer.
Yep, I think I would be making all the same points to the insurers or the solicitors, that everyone knows that a claimant who's got any injury, serious injury or soft tissue injury with the full spectrum will benefit from early and focused rehabilitation. And if that's funded by the insurers, then that's great. It means that you'd say exactly the same thing. This is ultimately, it means that the claimant's got the best possible chance of making the best recovery as early as possible, where possible. And therefore the cost of the case will be worth, the settlement should be less. So it's about appealing to the insurer's purse strings, really. We have a good, if you can agree a case manager, that often will help as well. I think if you do have a joint instruction for a case manager, then that can often help provide that independence in relation to what's being recommended. And I think that an INA is obviously the starting point. And that's sometimes where we don't always get, we've had situations where we've had INAs commissioned and then everything stops. And it's so heartbreaking to have to say to the claimant, we thought we were getting there. This is what dangling, this is what you could have had in terms of the rehab, but unfortunately it's gone quiet. And that is a bit of a frustration. And I get that is sometimes a difficult job for the UK handling agents or for the insurers or for the solicitors to sort of say, but it's just, engaging in the INA and then not following through is quite frustrating, but there can be those lost in translation, I guess, it's the benefits of it. And it can look a bit overwhelming, I suppose, a piece of paper that says all the things that I'm recommending, that the case manager is recommending that we have, but ultimately it is the benefit of the claimant's recovery, and that should be the focus.
I guess in that scenario, because I've seen it many times when an INA has been commissioned and nothing's happened, but then the claimant can say, if the claim's pre-issue, we're going to issue. If the claim is issued, we can make an application for an interim payment, both of which are going to cost the insurer more money. So that's the way we'll sell it back to our clients. Like, ultimately, we're going to be paying this because the claim's going to be issued, or we're going to be fighting an application when we don't have much leg to stand on in the application because the claimant obviously needs all of this. And so we do try to get early engagement on that.
And Craig, it's also part of your role trying to explain that although, for example, Spanish law might apply, English procedure applies. So although you might not get those things in Spain, because the ability to get extensive expert evidence here is probably as good as it gets, then the claimant might well be able to get the things that they're seeking, even though a foreign insurer might not feel that they should do?
Trying to explain English procedure to foreign insurers has probably been the hardest part of my job the last 10 years. And I think we're finally getting there with the clients I've been working with for a long time now. And so most of them do get it. When you're working with the big global insurers, for example, AXA, Zurich, Chubb, and so on, you've got branches all across Europe, it's fine. It's more the provincial, regional insurers that you really, really struggle with. It's very hard to get the message across to them who don't understand global litigation as much.
And I bet that includes costs as well, doesn't it?
Completely includes costs. That's the worst thing, trying to sell to a foreign insurer. And it's the main reason why, particularly in Belgium, people are doing the torpedo proceedings, because they're just so scared of English costs.
Well, absolutely. I'm sure and I were against each other at the beginning of last year, and we're getting to a figure, and at the end I thought, does that include the cost? And I was like, no, the costs are on top of that. And we've got a budget, you should know what it is, but sometimes reinforcing those issues are important. Okay, so claimant's looking to run the case here. Defendant might be going for cost reasons or whatever. No, run it somewhere else. In terms of looking for that early reassurance, Claire, that jurisdiction isn't going to be an issue, what are you looking to do there?
Oh, well, it's much
Particularly talking.
we've just heard the talk there from Dan and Sarah, but in the good old days, you had automatic jurisdiction majority of the time. So you put in your letter of claim, please concede, applicable law, English or whatever you're saying, English jurisdiction, and it was, you knew it would be fine because it was an automatic right. Now we're in a completely different world where you can put that in your letter of claim if you like, but you're very, very, very rarely, and Craig will definitely comment on this, but you're not really going to get anyone coming back unless you've got maybe the contractual, the consumer, the employment ones, and it's there expressly. It's going to be much more difficult now to get those concessions. So you're in a slightly different world as a claimant lawyer in terms of what you're advising your client at the beginning as to, we don't have the certainty that we used to have, which is frustrating all around because you're not able to say this is definitely a case that we're going to be able to keep in England. And these are the benefits of that. So right from the start, we're slightly on a different foot really. But I think you're going to talk. Yeah, I'll see what you say about it.
Yeah. Well, I think that's a key point we did say there is certainty. And one thing which I think claimants need to be aware, one thing insurers love more than anything else is certainty on a claim. And so it doesn't necessarily mean that we're going to bring a jurisdictional challenge on every case, even when it's, it seems like it can save money if you can do a deal. Got to just think, what does jurisdiction mean? Does it mean you're actually getting rid of the case? No, it doesn't, not always. I think Dan put it up quite clearly before when he talked about forum arguments, where they're actually trying to get the case struck because it's got no merits. Obviously, if the case has got no merits, then great, do a jurisdictional challenge because you'll save your clients the money of the case and costs. But if it's just an issue of forum, then all that's going to happen then is the claimant has still got a case. The claimant's probably going to be savvy enough now to instruct an Italian lawyer, a Spanish lawyer in his own right. If not, every claimant firm we deal with in this room has got connections to overseas lawyers and they just send the case that way anyway. So you're not getting rid of the case full stop. I've looked at some of the recent jurisdictional challenges and I've looked at the legal teams on board in those. You've got cases, you've got juniors, you've got experienced solicitors involved. And often the value of the case is actually quite low. And I'm thinking, where's the insurer saving money on this? What is the point? Why don't they just agree to deal with the case either in this country or even get slightly more creative? If it is pre-issue, you can agree or try to agree with the claimant. Okay, the main argument for trying to get this kicked out of this country is because we know that your costs are going to be very, very high. Try do a cost deal at the onset of the case, see if you can get creative there. It might mean the claimant's actually taking less money, but they're keeping the case and they're getting more money than if the case went over to France because they're still keeping some control of the case. So there's no reason why the parties can't be creative on costs at the start of a case.
Does the value of the case have a factor in your decision? Feel free not to share the trade secrets, but if you've got a low value case where funding, like in Belgium, is very restricted and there might be arrangements where the solicitors will have to take some of the damages out, the classic fast track case worth 15,000, you could knock that out quite easily. Whereas in the bigger cases, that they're going to be viable to run somewhere else. So is it the bigger cases where you think, well, it's going to be run somewhere, it's not worth necessarily incurring the costs on a jurisdiction challenge, whereas you get junior counsel to come along and fight a Part 11 on something lower, and you know that it probably will never see the light of day.
You've got to look at the whole picture. Some of the bigger cases, some of the bigger CAT cases we get will quite often get cost budgets from claimant firms between 700k to over $1 million, which foreign insurers just would never see that. You'd never see that in Spain, you'd never see that in Germany. So massive savings can be made just on the cost perspectives. But I see your point also on the smaller cases. It's what insurers tend to hate more than large cost budgets on big cases, because big cases have to be run that way, either in their jurisdiction or here. It's the smaller cases which say worth 30,000, then you get to bill from the claimant solicitors for 200k at the end of the case. They're the ones who I'd really like to get rid of.
Moving on to starting proceedings now. The claimants decide they're gonna roll the dice. Dan touched on the decision of Master McLeod in Charlton, Deptford. Is that causing you any concerns, Claire, in terms of how you're approaching things?
We now have a particular wording that we will offer to the defendants in relation to jurisdiction and the difference between accepting service of proceedings and they're leaving open the opportunity for them to contest jurisdiction. And I think that's important because I think that there are huge benefits in having a solicitor accept service within the jurisdiction and us not having to serve out. And again, it's that balancing exercise. A lot of these things are that they're going to contest jurisdiction. I mean, that's the world that we're in now with forum non-convenience and whatnot. So that's going to happen. So find that wording, offer it to the defendants, get the service within, and makes our life much, much easier, because then you're not going to have to make the application, get them translated, deal with the inevitable delays of the foreign process section, then do your application to extend time because the foreign process section are taking 12 weeks to deal with anything, etc., etc. We'll all know these consequences. And that would all go. And then obviously you have the ex parte application and the risk of all the full and frank and the usual arguments. By making that concession that you can still contest jurisdiction, you're giving yourself less of a headache when it comes to service. So it's that balancing. So we've got this wording that actually Sarah helped us in the case that we had, that it just gives that assurance to defendants that the Charlton thing we're not gonna push that. And again, it's clean slate when it comes to the forum challenge, the jurisdictional challenge. Let's go with that and go through the tests. But the issue of service is not going to come into it. So I hope that that's providing some reassurance.
And do you think that would provide reassurance to some of your clients? Great.
It's exactly what we've been doing anyway. From the other side, we've always recommended to our clients, certainly before Brexit, that instruct us to accept service because it's massively going to save costs and massively save time. Again, another thing which a lot of claimants that I come across think is that insurers try to drag their feet on cases. They don't. An insurer wants a case dealt with as quickly as possible. Instructing solicitors in this country to accept service will expedite the case massively. And so we have been using a version of that wording ourselves in any events. And thankfully, I did check with Sarah at the break if she thought it was valid and safe. And we won't hold her to that.
Moving on to the cases underway, and maybe it's not underway, but it's rolling on. You're thinking about experts. Now, it seems to me that there's going to be a real difference here between the approach on fast track and multi-track cases. Just dwelling on fast track for a start. Obviously, foreign law cases, it's dealt with a matter of fact. The court is going to need some evidence there. Package cases under Lockheed, again, need a report. And of course, we've got the potential repercussions coming forward with Griffiths, depending on which way that goes, controverted, non-controverted evidence. And fast track is really going to be the area of that domain. In terms of your approach, therefore, to proportionality and considering what you need to support your case, are you looking at insisting on getting your own evidence? If you're a claimant, insisting it's just you should get your own evidence and the defendant should sling their hook? Or are you going to be truly collaborative and agree to joint reports all the time? What are your thoughts?
Well, in a fast track case, for example, we would ordinarily get our local standards evidence quite early, because without that, we'd be unable to say, we'd have an idea if you've done enough of the cases over the years, but you wouldn't know for certain whether or not you could prove there was a breach. And therefore we would get our local standards evidence really early, and we would thread that through our particulars of claim, again, to make sure that you've got more chance of being able to rely on it if it's embedded within your particulars. So we wouldn't ordinarily collaborate on that. There are obviously situations where that doesn't happen now and again, and then you are in the you're having to persuade a district judge, firstly that you need the report, and secondly that it should be your own expert, and the defendants can ask Part 35 questions, and that's generally what we will argue. But I think because of proportionality, that's becoming less. It's becoming more difficult. And you are in the realms of the court perhaps imposing a single joint expert for local standards, which is not ideal because you don't have any control then.
If I can just jump on my soapbox dealing with these issues, very often you'll go into hearings and defendants and claimants have the same view, particularly in foreign law cases. We both want our own report, or we can see the benefit of getting a report from Mr. Sider or whoever it might be on local standards. But you've got a deputy district judge or a district judge who doesn't have a clue about these matters, does not appreciate that foreign law has a range of opinion in it, or various other, that the claimant needs to have a conference with their expert to understand the variations in the area of law. And what I find is when case summaries are clear, if you instruct counsel to collaborate beforehand, perhaps agree on certain issues in the skeleton argument, and explain to judges why local standard evidence is important, why it's important for both sides to take a view on law, to be able to talk to their experts, because of course you can't have that chat with a single joint instructed expert. I think that actually helps all of you. There'll be certain situations, for example, with a medical legal expert, where somebody will go, absolutely need one in France, absolutely don't, and you're relying on the Mielowski decision or something like that. But I think the more that there can be that collaboration in case summaries, using counsel who know what they're talking about as well, that can be hugely beneficial, hugely frustrating when I come across somebody who just goes, I don't know what you're talking about, and runs these silly points. So that's me off my soapbox. Craig, any thoughts on what I've just said?
No, I agree with your soapbox entirely. And I think in international cases, it is more pertinent, even on low value claims, to have your own expert evidence, certainly in relation to the foreign law, because you want to have your meetings with your experts and discuss that with him or her. And so I think it is certainly more relevant. And I totally agree with your point about counsel and also firms dealing in these issues which don't fully understand these issues. I mean, there's nothing more frustrating even for an insurer when we get presented with a claim from someone who doesn't do international cases. It makes the claim very, very much more difficult to run from the onset. It's almost you're guiding to the side along sometimes when these people who dabble in these cases who haven't got the expertise. And so I think it is important that these cases do find themselves with the right people at the onset as well.
And if the court does impose a single joint expert on you, what's your approach to actually agreeing who it's going to be?
That's one of the most difficult things that I do find, and I think me and my team are sitting laughing there because we have so many arguments in relation to this. You'll put forward an expert and quite often you'll get a blanket no. No reason why the other side doesn't agree with it.
Is that Mr. Sider?
No, not necessarily. I'm thinking more of foreign law experts here in this. It's a blanket no. And you'll explain, okay, this is not necessarily our preferential expert. This is one that we know has got a balanced portfolio of work. And they'll come back, if it's in Spanish, David Sanchez every time, which is a good claimant expert. But given the portfolio of work, I think you need to have some on balance, and it needs to be a rationale when you're suggesting an expert, and also a rationale if you're dealing with the other side of why you don't agree with their choice of expert. I don't think if a court's going to see the correspondence if you are going to a hearing, and just say no isn't helpful to anyone.
Yes, because ultimately, if you can't come to an agreement, it just goes before the judge, and then you are it is a bit of a lottery then as to what you get. So yeah, I think sometimes it is just about trying to put your heads together, if you have been able to do that, but it's not ideal, to be honest.
I can endorse everything you just said about, because it really does in court make a difference, giving the explanation and not just going, this person's good or this person is the one I want.
Yeah.
In terms of multi-track cases, you're obviously looking at higher sums and you might want to get experts involved earlier on, of course, put back issuing proceedings. Craig, you talked about memorandums of understanding.
Yeah.
You use those in these sort of situations as well with experts?
It'd be more pre-issue when you deal with that and you have your first meeting with the other side. It'll be very useful if you've both got an understanding of the case at that stage, just scope out exactly what experts are needed. And then that's when there is a bit of give and take between the parties. Obviously, a defendant would like, in most cases, fewer experts than a claimant. And I think in some, it depends on the applicable law. There's going to be some applicable laws where the whole panoply of experts you get in a normal English run case isn't going to make that much difference to the value of the claim, particularly if it's a very prescriptive regime. So you can have that discussion from the onset and try and say, these are the core experts both parties need, put that in the memorandum. If it transpires that later more experts are needed, then that can be discussed then. But if you can get the core team for both sides agreed and put that in the memorandum, that's how we like to approach it in that cases. On litigated cases, is obviously different because you need to go to a hearing to decide what experts. But again, you do try to have agreements before that.
Let's go to what we're ultimately moving towards now, and that is attempts to settle. And Part 36 offers with the new Quox regime are becoming even more potent weapon that the defendant can use. And of course, there's going to be some foreign law cases, Craig, where the liability regime is very prescriptive and will be known to your insurer. The means of calculating the case, probably on a more tabular system, again, is going to be quite obvious.
Yeah.
You might have an EL case and you already know what the earnings are, and you can fire right in early on and make a Part 36 while the claimant's still building up their case. Is that collaborative, or do you take a different view?
We have to act in our client's best interest at all times, to be perfectly honest, in that situation. And I said collaboration does look different in different cases. And that scenario is likely to be a low value case in a regime where it's very, very prescriptive. And I think the claimant's best interest is for their case to get the right amount of damages in the soonest possible time. That's slightly different to the claimant's lawyer's best interest because they're not going to be paid for as long in the case. But for the claimant themselves, they will get their damages quickly. And so it's a different form of collaboration.
Now, if the claimant were to say to you, that's great, Craig, it might be a great offer, but you've given me 21 days and I haven't got that report from David Sanchez yet. Can we have 42 days or a little bit longer?
I think if anyone's dealt with me in this room, that is exactly how we deal with things. We're very, very sensible in things like that. If the claimant's genuinely looking to find out about their case, find out more about the claimants, we certainly will give them the time. I've always been kind of brought up and trained myself, and that's how I kind of teach my departments. That's how we should deal with cases, looking at it that way.
In terms of multi-track cases, the bigger cases, Claire, where obviously it's going to take longer to even build up the knowledge as to what the extent of the injury is before you can even start to value it. Are you saying anything to defendants about trying to dissuade them from putting in early Part 36 offers? How do you approach that?
Well, I think now that the Quox rules have changed, I would expect there to be more early Part 36 offers from defendants, to be honest. And I think that it's, as a claimant lawyer, we do have to try it at the beginning now, perhaps to have more of an idea about our case and the value of it earlier than we used to do. There are certain countries where it's easier than others because they're more forensic. So we can do we can have a rough idea of what it's worth or what the risk on contrib is. So I think we probably, as claimant lawyers, we probably need to get a grip earlier as to the value of a case, so that we're ready if we are given an early Part 36. I'm not sure there's much I can do to dissuade a defendant from doing it if that's what they want to do, other than not send the letter of claim so early until we've got a really good idea of what it's worth. But then that has the effect of delaying things, which you don't want to do. So I think it's just try to be as early as you can, have a rough idea of what it might be worth of it. And if an offer does come in, you've got the best available information and also that a good connection with a foreign lawyer as well. I think that the PIOPL group is fantastic for making sure that you can get those links with experts. So if you do need a really quick advice on something, you can pick up the phone and there's some really friendly, fantastic PI lawyers who'll be able to give you that advice. yeah, I think the world that we're in now with the early part 36, they're going to have a lot more teeth. But as Craig said, if the offer's good and it's in the client's interest to take the offer, then us as lawyers, it's our job to say it's within that bracket and you should take it. There's no advantage to tell a client to reject an offer that's a good offer. There just isn't.
Again, it's difficult for defendants also on larger cases to get an accurate value from the very onset, in a particularly a catastrophic case. And there are things that can be done, and we have done in the past. And I talked about memorandums of understanding. What we've previously put in those where we've time limited, and we won't do a part 36 in the first 6 months, first 12 months. And what we've asked in return for that is access to the claimants, access to medical records. And it talks about being creative with costs. I think that is quite important now. We've put that in a memorandum, doing a deal with the claimants on cost at the onset and building into that as part of the agreement on not making a part 36 offers.
That's
and
sensible.
So it's a sensible way of
Not gonna
dealing
be
with it.
ambushed then,
Yeah, you're not going to be ambushed. And it's a
Yeah.
quid pro quo.
Yeah.
A defendant's not going to give up one of their biggest tools in the armory for nothing.
No.
But
Okay.
if you can get a deal and get the kind of things we've talked about there, then things can be done. I think there's more of a time now, particularly with the rules at the moment, to be more creative in discussions, particularly pre-issue on cases. And that's why collaboration can work, because you can talk about ways how to case manage it. And that's on claimants' costs, defendant not using a part 36 so early and so on. And both parties can get a good result by doing that.
Mm-hmm.
So we're now moving towards JSM. Claimants have got a report which is very optimistic from a claimant lawyer in country X who believes everything that's been said and it's skyrocketed value. Craig, you've got a report from an expert who's slightly more pessimistic and also makes certain observations about evidence, which perhaps they shouldn't do, but perhaps it's included within the report. But the court in country Y would never make those awards in any event. But you both know that it's somewhere in between, or perhaps you've even got an Eastern European case where you've got discretions between 50,000 and 2 million euros, and they can't really say because the judges just do whatever they want to. But you know it's somewhere in the middle. What's your approach to trying to bridge that gap, bring some sense to reaching a valuation where you might be able to?
I think don't agree at JSM until you've narrowed the issue sufficiently to think you're both genuinely going there to settle.
Yeah.
There's nothing worse from both parties. From a claimant's perspective, turning up to a JSM, getting the hopes up that this is all behind them and they're going to have the matter settled, turning up and nothing happening and going home disappointed. From an insurer's perspective, paying an absolute fortune to have 6 legal professionals in 2 different rooms and then eventually going home and paying for that privilege. And so I think you need to try and narrow the issues. And so you're both actually going to a JSM with every intention that you've got the possibility of settling.
Couldn't agree more. I've been to JSMs, recent ones, where everyone's there, everyone's engaged, and but then the insurer wasn't available or there wasn't an offer there. So yeah, I think that can be incredibly frustrating, and it probably sets back all the good work that's been done.
Yeah.
So yeah, I don't know. That's not obviously it wasn't one
No.
of your cases, but it can be frustrating when you get there and everyone's ready, and then you can't get the insurers on the phone, and it does happen.
It does happen, yeah.
Or I think we talked about there's a time zone problem, or a national holiday that wasn't aware of somewhere in Europe. So it's just, I think,
Colin and I had a wonderful settlement one afternoon, sunny afternoon, and our opponent got very cross with us at 3:45 when we said we've got 15 minutes. Why have we got 15 minutes? 15 minutes time, it's 5 o'clock in Germany. What's that got to do with us? Well, that's when our insurers put the phone down, and they're very efficient in Germany. They will put the foot down, the phone down. And he got very cross with me. Less so with Colin, but very cross with me. And also, there was my soapbox finding out 3:30 the day before a JSM that the 3 insurers on the other side haven't actually spoken to each other yet about contribution. And I saw an email early on today, and I say it's probably going to be shifted onto September. My clients are livid for understandable reasons, so they are an issue. But in terms of, when you do have these very polarized reports, and you do get some experts who are very much a claimant or a defendant individual, even though you might not be instructing them, some do believe in the cause a little bit more and can lack objectivity. I'm assuming one of the ways of bridging the gap is getting them in for conference and really kind of going through that and working out what's weak, what's not,
Yeah,
and all of those issues, so you can sort of bring that zone.
everyone has to be prepared. preparation is the key. Knowing where your strengths are, knowing what your vulnerabilities are, and narrow the issues.
Yeah.
Come with the right frame of mind.
And I think it's managing client expectations too. I think it's quite similar in international cases for defendants and claimants, because obviously a claimant's a layperson doesn't understand that this expert report may be biased one way, both the defendants and the claimants one. And also a foreign insurer may not understand that's pretty much the adversarial of litigation in the UK is both parties get almost polar opposite reports. So you need to bring your clients, both sides, into a more realistic position before JSM, so they don't turn up expecting you to settle at the value of what your foreign lawyer has said, but for both sides.
I think that's right. I think that often what happens is the last thing that the client has is the counter schedule, and then it's the JSM after.
Yeah.
So I think it's incumbent upon the claimant lawyers to have a conference with the client, take them through and work out those parameters so that you're right, so that on the day expectations are managed, and when figures start to be thrown around, they make sense, and everyone knows where the strengths are, where the weaknesses are. So again, it's just all goes back to preparation with your client, whether it's an insurer client or a lay client, and also and then collaboration with defendants in relation to, let's really make this work. Let's not waste anyone's time, because nobody really wants to go to a trial, not least the insurers, because it costs so much more money for you. But that's the theory. But unfortunately, we've all been at JSMs where that just hasn't happened, and it's the wrong mindset from the beginning, and it's just a waste of time. But it could be avoided with better preparation, couldn't it, for the parties that do turn up that way? And we've seen it from. Yeah, I was saying about defendants, they're not all claimants. No,
I've seen it from both sides. I've seen it with co-defendants, where co-defendants.
When you're dealing with
whenever the co-defendant turns up and it's been made, they've not made an offer all day, and it's been very clear they didn't have any instructions at the day. So why come?
I don't know about him.
Why come? Why come to a JSM when you haven't got any instructions at the onset?
It was an employer's liability case for somebody falling off some scaffolding. And one D3 said to me at the beginning of the day, "I'm not talking to you, I'm not engaging." I was like, okay. So talk to the other two. We reached a figure, and right towards the end, they said, a very well-known, relatively new Manchester Silk came up to me and said, "I'm terribly sorry, not £2.50 off this." D3. And they worked out their contribution. I just thought it's just incredibly unhelpful throughout the whole process. And we did not £2.50 or whatever it was to get it through, but it can be ridiculous. And I think that's where one of my last questions can be, what can counsel add? But overly aggressive counsel in that situation really didn't help. So I'm assuming the choice of who you were using on a particular case can also help with
all the rationale we've pointed for solicitors working together works equally exactly the same for counsel. I mean, that is very, very important. And I think, again, the market is even smaller for different solicitors for counsel who specialize in this area, and you all know each other very, very well indeed. And so I think the right choice from counsel who's an expert in this area, but also you want someone strong, but someone collaborative at the same time. And they are two things you can have in one counsel.
Right. Well, there are all the questions I've got for you. Now, audience, you've not been very active. You've got an opportunity now.
You've got him here.
To ask a defendant and a leading claimant partner. Gerald McDermott.
Well, it's not really a question. It was simply this, and actually, Ian, you explained there might be a few minutes at the end, and I might just give a few reflections on what become quite a long career in this area. But Craig, it's so refreshing to hear you recognise how important it is for claimants when they come to joint settlement. Jerome McCool once took me on one side, and I thought I knew it all. Said, "You've got to understand how big this is for this line." And actually, we did talk about it. In any catastrophic injury claim, I like to try and deal with it all day, but also explain to my fellows beforehand, this is a huge decision for the client. I might leave this open for a day or two, even just for the sake of it looking as though they're not being. But I think the one way in which the landscape has changed is collaboration. I've seen collaboration work so well. I've been doing this 40 years. I've been doing catastrophic injury cases 30 years. And I've heard of others, Craig. It's not just you. It's just refreshing that you recognise that this is such a big day for them. Most of my claims, I suppose, are over 5 million, some are over 20. And it couldn't be more important for them. And I'm sure that recognises that. One of the worst things I think is what's the insurer just isn't apprised of the issues.
Yeah.
And suddenly digs their heels in. And so it's an interesting dynamic. I think a great discussion.
Anyone else?
Might try the whole of the defendant. Dealing with personal injury things.
I have time to.
Is that next on the foil?
What I would say though is I would like to see defendants come into more things. It's great that Craig comes to things and you know a lot of people because of that. And I think that that means that when it comes to cases that we work on together, we have that trust and we know that we're doing a job. We're not trying to do each other's legs. We are doing a job for our respective clients in the best collaborative way. But because you come to things and your team comes to things, we get to meet people.
As your representative for England and Wales on Piopol, I am your rep. Craig and Nathaniel and I were talking last year about trying to get more defendant engagement in associations like Piopol. Obviously, APIL is a claims organisation.
Yeah.
If there are more of you who feel the same way as me, Craig and Nathaniel, and I'm aware that there are other members of Piopol who are listening to this, please share your views with me. It will give me more evidence to communicate to Piopol about involving defendants more, or speak to other people at Piopol, because as I've already raised with Piopol, there is a perception that Piopol is a little bit too claimanty, not a word that's a real word, but I kept on using a lot in a meeting. I got some very funny looks. But although Piopol is a great organisation with that regard, there is definitely greater value to people like Craig from the defendant side, feeling as if it is more inclusive. So if you do have any views, please let me know. Right, I am going to, on that bombshell, I'm going to stand down. Jared, would you like to close the conference? Thank you very much.
It's going to be a little briefer than this, and don't worry, it's not going to be long anyway.